Good afternoon, everybody, and welcome to the webinar, Overview of Stalking and Technology, Prosecution Strategies. My name is Charlie Whitman, and I'm an Associate Attorney Advisor at AEquitas, the Prosecutor's Resource on Violence Against Women, and I'll be moderating today's webinar. This webinar will serve as an overview of stalking and the modern technology used by the stalker. It will discuss investigation and prosecution strategies, as well as interviewing techniques designed to maximize victim cooperation and safety. It will also discuss offenders, the correlation between stalking and other forms of violence, lethality, and the importance of using a collaborative approach between law enforcement, victim advocates, and prosecutors to assist victims and hold offenders accountable. Before we begin the substantive portion of our program, I will provide a brief overview of our ILINC webinar service by answering 3 questions. First, how can I listen via computer and/or via conference call? I strongly recommend using our conference call line 605-475-4700, passcode 1003755#, and that you call in from a landline. If you are using a mobile phone, please do not use the speaker option. Listen with an earpiece if necessary. If your call gets dropped, please call back into the conference line as soon as possible. All call-in participants are automatically muted throughout the webinar. Again, that number is 605-475-4700, passcode 1003755#. And if you forget, the number is in the top left corner of your ILINC webinar screen. For those of you joining the webinar via computer, utilize the Internet audio by clicking on the Connect button on your start screen. If you use this audio option, please do not also call into the webinar. Only do so if you experience difficulty with your Internet audio. Second question, how can I seek assistance if I have technical issues? If you have technical issues, use the ILINC hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen, above the presenter's photo and to the right of the conference call number. Please take a moment to locate the hand raise option. Use the hand raise option to show me how many of you are using Internet audio today. Fantastic. Thank you guys so much. If you experience any technical difficulties, you can also contact ILINC directly at 1-800-799-4510. Third question, how can I answer and ask questions during the webinar? Throughout the webinar, questions may be posed to all participants. You can respond to questions in 2 ways. First, for any yes or no or multiple choice questions, use the ILINC feedback indicator located on the left-hand side of the screen. Let's try and answer a question. Have you previously attended an ILINC webinar? If the answer is yes, you have attended an ILINC webinar before, please click the button next to yes in the feedback option. If not, click the button next to no. I'll give folks a few minutes to respond. Okay, this is great to know. Second, if the presenter poses an open-ended question, you respond via private chat to me, located at the bottom left side of your screen. To ask questions or make a comment, use the same private chat option. You can just scroll through the list and check Charlie Whitman and chat that way. I'm the only one who will see the questions and comments, and I will share them anonymously with the group or our presenter. We encourage you to ask questions and to post comments throughout the webinar that we will answer and address throughout the presentation and during the question and answer period. At the end, if the presenter does not answer one of your questions during the presentation, please feel free to email him after the webinar. His email address will be provided. Finally, if you'd like to enlarge the content screen in ILINC, you can minimize the chat window by clicking on the arrow box in the left-hand corner of the chat window. If you'd like to reopen the window, please click on that same box again. Today's webinar, Overview of Stalking and Technology, Prosecution Strategies, is hosted by AEquitas, the Prosecutor's Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the webinar and the presenter's biography, will be available after the presentation. AEquitas' mission is to improve the quality of justice in sexual violence intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. EQUITAS provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. EQUITAS staff conduct legal research, provide 24/7 case consultations, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter will be EQUITAS Attorney Advisor John Wilkinson. Prior to joining EQUITAS, John was the Program Manager for the Gun Violence Prosecution Program, the Homeland Security Program, and the Southwest Border Crime Program of the National District Attorneys Association. He also served as an Assistant Commonwealth Attorney in Fredericksburg, Virginia, where he was a member of the Fredericksburg Area Sexual Assault Response Team. John also served as an Assistant Public Defender in Fredericksburg, Virginia. And now I'd like to turn the floor over to John for the substantive portion of today's webinar. Thank you, John.
Thanks, Charlie. I guess everybody can hear me, or Charlie would let me know if you can't hear me. Thanks, everybody. Good afternoon. Thanks for joining us to talk about stalking today. As Charlie mentioned, I was a prosecutor down in Fredericksburg, Virginia, which is a small rural city about an hour south of D.C. I'm actually in D.C. right now, and you might hear some noises from the street as my office is close to the street. So just ignore that. But anyway, I'm glad you guys joined us. We just want to talk about stalking cases and maybe some strategies that can help us go after these cases. I did a number of these cases, and they can be really tough cases. They're often not investigated as thoroughly as we probably should. The elements can be tricky depending on what state you're in and what your statute requires. Different states require different things, and some of them are well-drafted and some are not well-drafted, and we'll talk about some of those things. Victims can sometimes have gone through so much from the stalking and getting maybe an inadequate police response or prosecution response that they become very frustrated with the system and maybe drop out of the process. Meanwhile, we still have a often dangerous individual out there who's engaging in this behavior that can range from just harassing somebody to extremely serious behavior. And so we'll talk about a lot of those things and just some ways to maybe improve our response to stalking by collaborating with much more closely with law enforcement advocates and prosecutors and whoever else we might think we'd want part of our team to respond to these things. Most of all, we just want to make sure that we're educated about stalking and that we're inquiring about stalking, because even victims may not necessarily realize what's going on, and we need to ask them about it specifically to figure out if stalking is occurring or something along the lines of stalking. So some stats just to kick this off. 6.6 million people are stalked every year in the United States. That's quite a bit. 1 in 6 women, so it's more frequent where women are the victims, but it also happens to men, and 1 in 19 men. And these are stats that we picked up from the Stalking Resource Center. I'm going to refer to them a lot. They're hosted at the National Center for the Victims of Crime, and it's a great resource if you are doing these cases. If you're an advocate, if you're an investigator, if you're a prosecutor working on stalking cases, those guys have tremendous resources. I'll talk about them quite a bit. We reach out to them all the time, and we work with them all the time about trying to educate folks and come up with the best ways to go forward in these cases. So that's where these statistics have come from. I think when we think of stalking in general, we typically think of the stalker as the stranger stalker, and maybe typically we think of the victim as a woman. Don't forget that men are victims of stalking as well. It's not always the same kind of domestic relationship that the man might be the stalking victim of, but it can be that. It may be that a former boyfriend is stalking the new boyfriend, something along those lines to discourage the relationship. But we need to be cognizant that there's a lot of victimization going on out there. And these numbers, 1 in 6 women and 1 in 19 men, these are folks that had experienced stalking during their lifetime and felt afraid, had felt concerned about what was going on. And that's how they came up with that number. To just reinforce how dangerous this behavior can be, a couple more statistics. 76% of intimate partner femicide victims, of women who had been murdered, had been stalked by their intimate partner prior to the murder. So 76% of them. That's a really high number, and that tells us how dangerous this behavior can become. And that's also why it's a big red flag, a big indicator of dangerousness. If any of you are involved in danger assessments or risk assessments when you're working with victims of crime, typically victims of domestic violence are who we work with danger assessments, and we'll talk a little bit about that in a few minutes. 89% of those femicide victims who had been physically assaulted had also been stalked in the 12 months before their murder. So you see how dangerous it is, and also that there's escalation in behavior. There's stalking, there's physical assault, and then ultimately homicide. So this doesn't mean that every case of stalking winds up that way. It's just that there's a tremendous potential for danger, and so we do have to treat it very seriously. And I think that's one of the challenges sometimes, at least with the judges that I had, and typically there was always a relationship involved, and they just didn't quite see it as dangerous as I think it actually is. And we were probably lucky that I'm not aware of any of our stalking cases, that some we won and some we lost, that ended up in someone dying. But it does happen, and so we do need to stay on top of that. The stalking behavior most often occurs in the context of an interpersonal relationship. So it's usually that there's some relationship there, and whether it's a domestic violence relationship, whether they were dating, whether they were married, divorced, whatever it might be. So that sort of myth or that image that we have of the stalker is the stranger going after the celebrity or the attractive individual or someone who was kind to them or what have you, is really not the accurate picture. It's most often happening in this relationship. And I think if you're doing these cases, then you've probably seen that there's some relationship. It's usually a domestic relationship of some sort, a dating relationship, something like that. Even if it wasn't a very long one, this is what can happen. And so we need to recognize that. And because so often it's in a domestic relationship or that there's some relationship there, every time we get a domestic violence case, we want to be evaluating it for the presence of stalking, just in case there's stalking present in that relationship. And it may not be something that a victim is going to volunteer or may not even consider themselves as a victim of stalking, particularly in a domestic violence case. I don't know how many of you have seen this short movie called Telling Amy's Story, but it's a story about a domestic violence homicide. And they just sort of go through this relationship. They had 2 kids. They were married for a few years. And this abuser just increasingly was more controlling, trying to gain power. And as they tell the story, you can really see how it's his wife, but he's really, and they live together, but he's really stalking her. Drops her off at work, picks her up at the end of the day, calls her 10 times a day, asks where she is she out to lunch, is she with somebody, like jealous rage, that sort of thing, and he ultimately murders her. But it's not something that we typically think about in these cases, and it may not be something that someone who reports domestic violence will volunteer or think about as important. They may be calling 911 to get help for this immediate assault, the instant assault, and that's what they're going to tell the police about. They may not tell some of the other things that are going on. And, of course, if they're living together, I mean, that's going to be a very tough stalking case to make if you were to charge stalking. But you can see the behavior there, and there are other things that kind of behavior tells us, and in particular how dangerous a relationship may become, and maybe informs us as to what resources we need to at least offer these victims so that they become aware of what's going on and that they have somewhere to turn to for safety and for help. In addition to police and prosecutors, advocates can provide them with a great deal of support and some just basic resources such as safety planning and other things that we'll talk about that can be really helpful to a victim and very practical help that they need at that time. So we definitely want to be looking at our DV cases and asking affirmatively, proactively about stalking. That's the only way in a lot of these cases we're going to ever find out if it's going on. And there's some other additional benefits to doing that we'll talk about when we get to the prosecution section of the presentation. And so stalking is not exactly a crime of passion. I mean, often that's going to be a sticking point, or that's going to be a defense that is put up there that the individual is not doing this to frighten somebody. They're doing it because they're in love with them. And that can often be the hurdle that is difficult to overcome for judges and juries. And because in Virginia where I practice, stalking was a misdemeanor, except after multiple occasions, three on the third offense, it could become felony. Typically, they were tried in front of a judge for us, and the judges really hung up on that intent. Why is this individual doing this? I don't think it was to put the person in fear, but it was that they were in love, whatever. So that's a tough one, and we have to address that, and we'll talk about that. But so it's not our typical crime of passion. What I'm really talking about is it's not an impulse crime that somebody does suddenly without thinking. They plan these things out. They know their victims very well. That's why this is such a disturbing crime, and that's why they're able to be effective at it, because they know if you've dated somebody, you know their comings and goings, where they work, where they go, who they socialize with. It's very easy to interrupt and harass them and interrupt their lifestyle if you know all those things and gain information about them. You also probably know ways to upset them, things that make them on edge or upset, and just how to push a person's buttons. As probably anybody who's been in a relationship knows how to do, but you don't do it in a criminal way. So we have to recognize that and look for that evidence that shows that this isn't a coincidence. This isn't something that just happened. These are things that they're doing deliberately. This is a plan, and we need to look for that evidence of planning. It's meticulously orchestrated, and it's designed to have an impact on the victim psychologically. And it's also, when people take advantage of modern technology, it's also done in a way to avoid being caught by the police. So technology is a great aider and abetter of the stalker because they can come up with creative ways to garner information about their victim but hide their tracks. So it's not clear how they happen to be at a certain place at a certain time, or how they happen to know information about an individual that they shouldn't know because technology has allowed them to hack into someone's computer or account or what have you. And we'll talk about that also. Context is really critical in stalking cases because there may be behavior, as you think about what goes on typically in a stalking case, it typically would start out with just some sort of surveillance, maybe just watching somebody. It's behavior that may not be criminal, an isolated incident on its own, that somebody happens to show up at a restaurant somewhere where the victim happens to be. That there's nothing illegal about that. But when the course of conduct is done repeatedly and done in a way that is clear that they're trying to harass or upset or cause emotional distress to an individual, that's when it becomes criminal. But that context of what the person is doing is really important for us to identify stalking to begin with. So something might seem innocuous, but it's not. It's got dark connotations. A typical example that the Stalking Resource Center will talk about is a victim that called the police, was extremely upset. They asked what happened. She said, I came home and there were a dozen roses on my front porch. And so, of course, the police are thinking, okay, we've got a live one here. This is crazy. What's wrong with that? And you have to get a little more of the context, a little more of the story. And the victim reveals that when we finally broke up, what he said to me is, the day you get a dozen roses on your front porch is the day you're going to die. And so we need to get that context to identify this behavior, what it's intended to do, why the individual is doing what he's doing, and what the impact is on the victim. So that context is really important. We got to ask a lot of questions of our victims. They may be very upset. It may seem like they're maybe difficult to deal with. And I've had some victims of stalking that I've dealt with that are difficult, and they're very upset and they're very frustrated, and they feel like no one's believing them, no one's taking this seriously, and that no one can protect them. And so sometimes they seem difficult to us, but we have to persevere, understand, provide them with support and services so that we're able to find out what happened and go forward if we're able to. It's a wildly underreported crime. So approximately 60% of victims do not even report to the police. And as I was just talking about, they often lack confidence in the system to protect them. But another part of it is people don't recognize that they're being stalked. If you were in a relationship, married to somebody who routinely called you 20, 30 times a day, picked you up, dropped you off, constantly knew your whereabouts, you might that might be typical behavior to you. You might not recognize that you're being stalked. Or you may not have connected the dots yet, that these things aren't coincidence, they are deliberate because they've happened in a certain way. A lot of victims also just feel like they can handle it themselves, or if calling the police may escalate the behavior, they don't want it to go that far. So there's a lot of reasons why it is underreported, but it is underreported. So it's important when people do have the courage or the need to come forward that we treat these crimes very seriously, listen to them, make sure we're doing everything we can to investigate the crime, treat it seriously, provide them with the services that they need, and protect them to the degree that we can. And so we have to communicate with them all sorts of things, the resources that are available, simple safety planning that they can engage in themselves, that we can help them with, danger assessment so they can hopefully be apprised of maybe how dangerous this individual is, even if they think they can handle the stalker. All of those things are important. There's a lot of challenges to stalking. We've talked about some of them. So it's typically not a single obvious criminal act like our typical crimes, car theft, robbery, burglary, whatever it might be, that we're very well equipped and very adept at responding to. It's multiple acts that aren't necessarily on their face criminal behavior. So we have to do a little more investigation and connect the dots about what's going on. Another challenge is that impact on the victim. The fear can be an element that prosecutors have to prove in the stalking charge, depending on how your statute is written. There's almost always going to be some fear element or at least some element that requires demonstration of emotional distress. On the fear element, that can be a challenge because sometimes victims, you'll ask them and they don't want to say, no, I wasn't really afraid. They don't want to say that they were afraid, but they maybe are minimizing some of it for self-protection or for other reasons. It just may be a natural thing that people do. And they don't always want to give us that information, so we have to prod a little more and figure out if that fear element was there. Sometimes the statutes require that it be fear of a specific thing, like fear of murder, serious bodily injury, some other physical assault. And that can be tough sometimes, depending on your case and what the facts are. And so maybe ways to go at that are to figure out the history of the relationship. Was this a domestic violence relationship that the victim just never called the police about, never reported assaults, but they happened, and it's very reasonable for her to fear physical assault. We need to get into all that stuff. Some of the other challenges are the stalking incident is overshadowed by the domestic violence incident. We respond and there's an assault and there's a black eye or a bloody lip or what have you, and people are upset, and we're just trying to meet that incident. And we don't think to ask other questions about what's going on. If our officers are equipped to do some basic risk assessment, danger assessments, they may reveal some of this information. And it doesn't just end with the investigation and then we get the case and that's where we're at. We can ask the questions ourselves as prosecutors about what else may have happened and try and find out more information, even if it's gone beyond the investigation stage and we're meeting to prepare for trial. We need to know all those things, and victims may tell different parts of the story at different times. They may remember things differently. People who undergo trauma often respond in different ways. They often remember things differently, and they'll often tell you things differently, particularly somebody who may be the victim of domestic violence. It may be tough for them to talk about some of these things. So we have to ask. We have to be proactive in that. We have to be effective in our investigation of stalking cases. The behavior can cross jurisdictional lines. It can involve reports from other counties, other states that we may not know about, and we need to investigate those things. So we do need to be collaborative amongst law enforcement agencies and also amongst our allied professionals. Advocates, anytime you're dealing with something related to domestic violence, advocates can be a huge resource, a tremendous tool for investigators and prosecutors. They can't always tell us everything we want to know. They have confidentiality agreements, but just providing the support to victims will often just make a victim a stronger person, a better witness, and someone who wants to go forward, wants to participate in the investigation and prosecution of this individual, and somebody who recognizes that they don't have to be a victim anymore, that what's happening to them is not right and it's not their fault. So they do provide a tremendous, advocates can really provide a tremendous resource for us, and we should take advantage of that every chance we get. We talked about it occurring across jurisdictions. Stalkers aren't easily deterred, and if you're doing these cases, you certainly know that. Excuse me, I had to take a sip of a drink. I mean, I've had these guys, and the typical case is, it starts out with the girlfriend tells him, look, I don't want to see you anymore, and he didn't listen to her. And then you might get family or friends to tell him, hey, she really doesn't want to see you anymore, and he didn't listen to them. And then you get the police to go talk to him and say, hey, she doesn't want to have any contact with you, and he doesn't listen to them. And then we prosecute the guy and bring him before the judge, and the judge finds him guilty and orders him not to contact, and he doesn't listen to the judge. They're not easily deterred. They continue to do this, and we see it again and again and again. And maybe you don't have all those facts in every case, in each of your cases, but that is a strong argument to make in court that this is typically what happens. We need to take it seriously, and even if your judge isn't going to impose a heavy, active jail sentence on a first offense of stalking, there needs to be something hanging over a person's head so that we can protect these victims and to deter that continued behavior, because these guys very often, sometimes it is enough. One or more of those actions is enough to stop a particular stalker, at least for that particular victim. It doesn't mean they'll stop stalking people in general. But often we need more of a hold on these folks to maintain our victims' safety. That's our main priority, is keeping our victims safe. And we know that these guys just don't listen. People don't tell them what to do. They tell other people what to do, typically their victim. And so we have to recognize that and make sure that we stay on top of these guys. Incarceration doesn't necessarily stop the stalking. Arrest doesn't necessarily stop the stalking. Sometimes that is the thing that ratchets up the behavior. So we have to recognize that safety, particularly in stalking cases, anytime you're dealing with victims of domestic violence or stalking and sometimes sexual violence, safety should be an issue that's at the forefront of our minds constantly, and we should always be asking about it. Investigators should, advocates should, and prosecutors. Sometimes the prosecutor is the last person that these victims will see before you go to court. Danger, intimidation, those things ratchet up typically right around court appearances. Could be right before arrest, some behavior while we're waiting for trial, and then right before trial is when they really ratchet up their behavior, the intimidation, threats, whatever it might be. So prosecutors really need to be asking about this too. Do you have a safety plan in place and we'll talk a little bit about safety plans in a minute. And has anything changed? Has this individual been contacting you? Even if they're in jail, are they calling from the jail? Do we review jail phone calls? Can we review them? Does your victim tell you as you're preparing for trial, yeah, he calls me from jail 3 times a day and asks me not to go forward? Are there other charges that we could bring in addition to stalking or in addition to the domestic violence assault, whatever it might be, that involve witness tampering, obstruction of justice, something like that, threats, intimidation, anything like that? We've got to ask about those things, mainly because it's a safety issue, but it could also be additional evidence, could be evidence of consciousness of guilt that an offender is asking a victim to drop charges, to not show up, or threatening a victim if they do show up. It could be additional evidence of an additional crime, of intimidation, or something else. So we need to ask about those things and think about those jail phone calls because, again, stalking cases, there's always going to be that defense or that other story that it was either a coincidence or I had no intention of doing that. It's not that I am trying to threaten or harass her. It's that I love her. That clouds the issue. The relationship, the existence of the relationship, the domestic relationship, the dating relationship, whatever it is, automatically clouds a fact finder's view of what's going on here. People just, for whatever reason, when there's a relationship, a marriage, a dating relationship, it's difficult for us to see that the one party in that relationship is committing crimes against the other party for whatever reasons. It's often a challenge for us and a challenge for the fact finder. So we have to break through that and recognize that. Jail phone calls can be a huge asset to figuring that out. So look for that information too. Stalking is rarely charged. So it's underreported, but then even when it is reported, it's only being charged between 5 and 16% of the time. And that's from a study that you can access via the Stalking Resource Center or through the site that's at the bottom of your slides. And it's sort of an amalgamation of many different studies that talk about how often we get stalking charged. And then the number of times that we achieve convictions is a smaller percentage of that. So you can see how victims and individuals who have been stalked might really think, gosh, there's not a lot they can do. This just doesn't result in convictions all that often. And it's because probably we're not doing the best job of educating our judge or jury about it and even educating ourselves about it. That's where it starts. If we're not up to speed on stalking behaviors of the offender and how victims react to it and what they may do as a result of the stalking, then we're not going to be able to identify stalking. If we can't identify it, it's going to be tough for us to convince a judge. So we do need to make sure we're educated about these behaviors and what's going on as we go forward in these cases. And this is just a chart which is just our typical response to crimes and maybe why we don't identify stalking right out of the gate. Typically a victim calls 911 about some isolated incident. Law enforcement investigate the isolated incident, and they use that history that they obtain as a point of reference to process the alleged crime. So it may be an assault, and they just talk about the assault. They don't get into other things that's going on in this domestic violence relationship. So because that's often how we respond to these, and that's not everybody. There's great law enforcement folks who can recognize something else is going on here and figure it out. But sometimes it might be the prosecutor or even victim witness in a prosecutor's office that may be better able to recognize the stalking behavior or that stalking is going on, may be able to talk to the victim and pull additional reports from different places to identify that. If we get law enforcement on board and they're investigating that way, and anytime there's a crime involving harassment or domestic violence, we're inquiring about stalking, they're going to do that for us. But sometimes it might be the prosecutor who's able to do it. Sometimes it's the advocate who recognizes this. And if they can communicate with law enforcement via permission from the victim or get the victim to talk to law enforcement, that's another way. If we're all on the same page looking for stalking, we're going to find it more often and be able to identify it and address it effectively. So our victim interviews, we've got to be a little more expansive and talk about what the defendant has done that scared her or upset her or causes her concern. Be careful about the language you use, because victims may not want to say that they were scared or upset. But just what else concerns you about this defendant? What else has he done, either in the past, or what are you concerned he might do in the future? Was he in prior relationship? What else was going on with this guy that caused you to be this concerned or upset or whatever it might be? What was it that made this incident so scary or so upsetting? If it's innocuous behavior, if it's just seeing somebody at a restaurant, at a bar, they were in the parking lot that you were in, at the grocery store, you're at your parents' home visiting, whatever it might be. What was it that made that scary or upsetting? See if you can get them to tell you a little bit more about their relationship, the context, the history. Have you changed your routine or other aspects in your life due to the defendant's conduct? Things like that can be, if you have a victim that is maybe not telling you exactly that they're afraid, but you can get them there, that kind of circumstantial evidence, that behavior, indicates that a person is afraid. I'm so concerned about this stalker, this former boyfriend or ex-husband or ex-wife, whatever it might be, that I've actually changed my routine. That's an indicator that someone is actually concerned or afraid or emotionally distressed, if that's what your statute allows you to prove. If your statute has that prong of emotional distress, that is typically the easiest prong to prove. It could be simple fear. It could be that the victim was in actual fear, or that a reasonable person, it would have caused fear in a reasonable person, maybe the easiest way to go. I always like the emotional distress one, which Virginia actually doesn't have, so it's not that great. But it, to me, is an easier way to prove that someone was upset or disturbed by what happened. Are there any police reports in other jurisdictions? Does the victim realize that it's important to tell you about those things? Are there any other contacts that the defendant has made? Does he know your passwords to your computer, to your bank accounts, to work accounts, or whatever it might be? Even if you don't think he knows, would he have ever had access to that? That may be a way he's gotten into a victim's personal information to predict or figure out where they're going, to read emails, find out who they're now seeing, find out who they're hanging out with, and use that information to cause them fear, cause them terror, cause them emotional distress. So to be effective, we've got to know the context, and we've got to gather as much information from multiple sources. Friends and neighbors, family members can also be good sources of information. How concerned are they about this individual and the stalker? The victim may be minimizing what the stalker's doing because they know the person, they think that they can handle it, they can control it. But other people sometimes have a clearer picture and might be more concerned. They can be a good source of information. This is a lot of things that when we're investigating stalking, we need to do. They require really thorough investigation, just like domestic violence crimes require. They require a tremendous amount of investigation for us to be successful. We want to investigate them in an evidence-based manner so that we document everything independent of the victim, describe, photograph, collect everything we can, document or record statements from victims, from witnesses, from the defendant if we can. And so that we have all that information, and if necessary, just like in domestic violence cases, we are able to go forward in a stalking case, even if we may not have the victim. We'll talk about a couple strategies for being able to do that. Again, these cases are tough right out of the gate when you have everything lined up. When you don't have a victim, that's extremely tough. It doesn't mean you can't go forward. There still are ways you can go forward, and we'll talk about that. We've talked about a bunch of reasons why these cases are tough. Multi-jurisdictional. Most statutes require at least one incident in the course of conduct to occur in your jurisdiction to prosecute it. But other instances could happen in other counties in your state and or out of state. So that's a challenge, but there's ways to meet it. It has to have a course of conduct. There has to be more than one incident, one piece of behavior to charge stalking. Every stalking statute requires that. So you do have to have additional piece of information or additional piece of behavior. That doesn't mean you can't charge whatever was done at that time if it violates a criminal code. It could be a trespass, it could be harassment, invasion of privacy, something like that. Look at your codes. What else do we have that we can go after? They're hard because victims are frustrated. They're often told by police and prosecutors that there's nothing we can do. He has to do something else before we can go after him. Well, that gives a victim a great deal of confidence and a great deal of comfort that they basically have to be out there as bait to get somebody to do another act before the police can get involved. And convincing judges and juries that the behavior is dangerous is a challenge also because they don't quite see it because of that relationship. We should improve our communication and information sharing among law enforcement agencies to be more effective in these cases. So if you are in a jurisdiction that borders several states, can you share information with the agencies immediately adjacent and across state lines to you, come up with some formal system to be able to go after that more effectively. Some things benefit us in stalking investigations and prosecutions. It's the same victim, the same offender, typically the same locations. They target home, work, common social places, and it's a course of conduct. So those things can be advantages too when we're investigating these things because it focuses on what we're looking at and what we're looking for. So they're not always just tough cases. Look at all these crimes when you're dealing with stalking. They could be something that's going on that indicates we should be asking about stalking. If there's a restraining order violation, those need to be treated seriously. We don't always treat them seriously. Those are often easy charges to get convictions on if you can just establish the basic elements. But let's ask about stalking. He was ordered not to go near this individual, and he's now going near them. Why? Is he stalking? Is this intentional? What's going on with that? All of these things can involve stalking, and we should look at it. Threat assessments are important. If you're a prosecutor, you may not be doing these, but you should be aware of them, and you should be asking that someone is conducting a threat assessment for our victim. And there's a couple that are out there. Dangerassessment.org is one that we often refer to. That's done by Dr. Jackie Campbell, who's done a good deal of research on danger assessments and the potential for lethality when you have certain factors present. So it's going to be our first thing that we want to do to help our victim. One, it can indicate to the victim that she's in a more serious situation than she may realize when you actually ask these questions, lay out a calendar, ask about incidents of abuse, arguments, threats, whatever it might be. It also can identify very dangerous red flag behavior. Stalking is a big indicator of lethality. It is a very serious, dangerous behavior. Forced sex in a relationship is a very big danger when it comes to danger assessment. Strangulation, extremely risky behavior. It's a big red flag. So let's look for those things and ask about them. But maybe we can also use these when we're arguing for bail or release conditions or sentencing recommendations. Can we educate our judge with an expert on danger assessments and educate them on how dangerous stalking is and this behavior is, and that we need special conditions in this case? And it may involve limiting access to technology by the defendant. That may be a tough thing to argue to a judge, that this guy should not have a computer because he uses the computer to stalk and harass the victim, and so we have to limit their access. That may be a stretch for some jurisdictions, but if you have the right facts of the case, that's something that you want to look at. Mosaic is another, mosaicmethod.com is another danger assessment. They do a whole bunch of different danger assessments, but they do domestic violence ones, and they are also highly thought of. So that's another, there's not just one. Look at those things. You can become pretty familiar with it fairly quickly. They have online tutorials that can educate you on how to do these and what the research is and what these things mean. And it can be powerful evidence and argument for a judge at bail, release conditions, revocation of bail, and at sentencing. You certainly wouldn't be able to use this in your case in chief, but it's good to know. And if you educate a judge at a bail hearing about the dangerousness of it, of course he's going to retain that for trial, or be aware of it at least during the trial. So let's talk a little bit about technology in stalking. Of course, stalkers use all sorts of technology, from basic things, just calling to harass somebody, texting to harass somebody. You know, there's a lot of cases out there of victims who, I mean, if you can imagine how serious this is and how we should take it seriously, of victims who have go into a panic every time their phone rings, because that's how the stalker got at them, or every time they get a text message, there's fear, even if they've cut off contact with the stalker. That's how powerful these guys can be. But they don't just use phones to call and text. They can use spoofing. Spoofing is where they can use technology to create a fake phone number. Sometimes they can create a fake voice. They can leave a message that's threatening that goes to a number that the victim doesn't recognize and is left by a voice that the victim doesn't recognize. And the victim probably knows, gosh, it's so-and-so, but I must be crazy. He's gotten somebody else to call me. So that's something that we need to look at. Stalkers, the really savvy ones, can also use this technology to make it look like the victim has been contacting them. They can spoof the victim's number to call their own phone and or leave a text and create a text message. So it looks like the stalker is being contacted or even stalked by the victim. That's a classic way for them to turn the situation around. And now suddenly the police are in the position of having to investigate the victim. But if you're aware of the technology, one of the things you're going to do is figure out, have you called him, have you contacted him, when, and what did you do? Because some victims will still contact their stalkers. For some victims, it's a way to keep track of them. Stalking Resource Center had a victim, and they've told me this story, where the victim called the offender every morning because she then knew he was at home and she could go to work and feel relatively safe. He wasn't going to leap out at her, things like that. Talk to him for a few minutes and then go on. That's how she managed her stalker. It may not be the smartest way or the best thing, and it may be difficult evidence in a case for us to handle, but we need to investigate it. If she's contacting him and it's not anything unusual, it's not threatening, let's know what those contacts are, when they occurred, get her phone bill that indicates when messages were actually sent from her phone rather than spoof messages that a stalker may want you to look at. They can also use phones as a listening device. There are ways to access the victim's phone and turn on the phone but turn down all the sound or technology so that it doesn't appear to be on. But now you can listen to whatever conversation the victim's having as long as the phone is nearby. Phones can also have GPS devices in them so that you can locate your phone. I'm sure a lot of people do that with their iPhones. One stalker installed a phone in his victim's car and had it connected to an independent battery power source so that he could always track the victim by following the phone. Computer and the Internet are classic ways to stalk and gather information so that you can stalk an individual. There's all sorts of spyware that can figure out what keystrokes the victim has done so you can recreate, identify passwords, figure out messages that they've sent, things like that. If there was a dating relationship, technology could have been installed in the computer during that relationship. It could have happened since the relationship. An individual may know a victim's password and use that and get into their computer and install spyware so that they can remotely surveil them and figure out where they're coming and going. You don't have to know all the ins and outs of the technology, but just be aware that these technological capacities exist. And anytime a victim's telling you something, a lot of times stalking victims will sound a little crazy because what they're saying doesn't quite make sense, and it seems like that it would be impossible for a stalker to know all these things, therefore it must be a coincidence, or the victim is excessively hysterical about this. Just be aware that this technology exists. You can get help from all sorts of agencies that are adept at investigating technology crimes, including the Stalking Resource Center, which has great information about stalking and technology. They have an online video. You can order it, get it for your office, that goes into much more detail about technology and what they can do and how they use it to stalk individuals. It's great information. You should definitely get a hold of that. Hidden cameras can be used, webcams, recording devices. You can get an individual GPS device, put it on a car, things like that. All that technology exists. The victims aren't crazy. We do need to take these crimes seriously and figure out if stalking is going on. Coincidental encounters are often not coincidental because of the technology that's used. So if there's a series of coincidental encounters, we should start thinking that technology is involved. There's often barriers to reporting stalking, that there's behavior going on, but the victim suspects the offender but can't really pinpoint why the offender would know these things or be able to do these things, or even that it's the offender if there's spoofing going on or a voice makeover that allows them to do this. So it appears to be coincidental, but it's not. We need to look for that. Victim disclosure suggests stalking patterns in the use of technology by offenders, so let's look for that, pay attention to it. Requires us to appreciate modern technology and have more sophisticated victim interviews so that we're getting at that information. The tools may be new, the technology may be new, but the crime is the same, the behavior is the same. They're doing this with the intent to harass, cause emotional distress, cause fear, cause terror in these victims. So let's keep looking for that. When we're investigating these cases, we want to identify all potential crime scenes and all potential evidence. They target every aspect of the victim's life, home, work, family, friends. And so we need to look for all those things. It might involve showing pictures. Has anybody seen this person around the workplace, this vehicle that belongs to the offender around the workplace, around the home, in the neighborhood, whatever it might be? Friends may know the stalker as well and might be able to have some more information to tell you. Sometimes stalkers use friends unwittingly to gather information about the victim and engage in stalking that way. We want to know the history of the relationship. That may be the best source of information if we have to prove the element of fear, that it was reasonable for this victim to be afraid. That context of that prior relationship may tell us what fear was present and whether it was reasonable if you have to prove that element. Is the behavior indicative of stalking? How was the individual being stalked? And is technology being utilized? We want to cover all those things. We need detailed incidents. We need to know everything that has gone on when we're investigating these things, and maybe flag reports so that you can link them up if they're stalking or harassing or alarming behavior, so that when the next incident happens, it's easy to find the previous incident. We've talked about victims and why they get confused, angry, and upset. We need to build trust and rapport with the victim, let them tell their story, show them empathy, provide them with support if you have resources to do that, and educate them on what's going on with stalking, and preserve the victim's statement via audio or video recording. Often that fear, that level of fear, can best be captured that way rather than have to explain. Also want to explain to them why it's important to preserve all the evidence of stalking. You want to develop a timeline of events so we know when the stalking behavior began. Don't start the timeline too late. You want to capture every incident you can, and don't end it too early. And the timeline may continue after arrest. There may be additional behavior that would be relevant to a trial, even though it happened after arrest. And so maybe you have to amend your warrant or your pleadings to incorporate new behaviors that occurred later. So think about those things. Obtain contact information for a safe relative or friend. That should be part of the safety plan, too, for the victim. Does the victim have a place to go? Do they have a way to get out of their house? Do they have car keys, some cash if they need it, change of clothes, that they can quickly get out and get to a safe place? The stalker probably knows most of the victim's relatives or friends. Just make sure it's a safe place that the victim has, and make sure you have that contact. Ask about the previous incidents of stalking or domestic violence. We really want to know that. And are there any people that are aiding this guy, whether it's wittingly or unwittingly? We want to know about that. stop all contact with the suspect when we're talking about victim safety. That's going to be the best way. But think about some sensible things. If the offender is constantly texting or calling the victim on her phone, it may be smart to keep that phone active and get the victim a new phone that she can use as her regular phone. But this is going to be the place that the stalker contacts or accesses the victim is through her phone. If that's cut off and he realizes it, then he's going to do something else to gain contact. If that venue is still open, it can create additional evidence that we can collect, and it can protect the victim because he has an outlet to go for. He's sending those messages to that phone, even though she's not collecting them anymore. Might want to keep that phone active, that account active, and just get another phone and make sure nobody shares the new phone information. But we can still collect evidence via the phone or via the email account or whatever it might be. Discuss technology safety, particularly online, Facebook, things like that. Just be aware that when photos are posted to Facebook, they have a geographic tag in them that someone sophisticated with technology can figure out where you were or maybe where you are, or if you're on Foursquare or some of these other things where you check in. If you have somebody who's stalking you, you need to stop that stuff immediately and just engage in behaviors in different ways. So make sure that your victim knows about that, and we have a discussion with them about that. They should keep a log of all the attempts to contact, including dates, times, witnesses, if there are any evidence that suggests contact, letters, even if it's an apology letter, phone calls, whatever it might be. Take a screenshot of text messages, preserve that stuff if your phone doesn't already in some way. Investigators need to do that too. We just want to keep all that evidence for us when it comes time to try the case. Educate the victims about stalking. Protective orders are an option. Those don't always work. Sometimes they can escalate the situation, but it's definitely an option, and sometimes it does work. Talking with law enforcement on campus, stalking is a behavior that occurs quite a bit on campus as well, and it occurs in that younger population quite a bit. But campus officers have told me that a high incident, when they contact the stalker or the alleged stalker, that 85–90% of the time that individual no longer stalks the victim who has complained about the contact. And that's not statistical, that's not reliable, that's anecdotal completely. But that can be a help to have law enforcement contact the stalker. It can also escalate the behavior, increase interest in the victim by the stalker. So we have to be careful about that, but that can be a good way to go. And hook them up with services, with advocates, things like that. Give them the tools to document things that are going on, whether it's journals, calendars, logbooks, whatever it can be. And identify the things that they may be used to this individual talking to them in a certain way, directing them or ordering them to do things, threatening them, or the apology, the I'm so sorry, this will never happen again stuff. That's all evidence we can use. It's evidence of consciousness of guilt. It's evidence of continued contact, continued threats, continued harassment. Victims don't always realize that, and they don't tell us about it, and they don't preserve letters or text messages or phone calls or things that would indicate continuing criminal behavior. So we need to educate them about that, tell them to preserve it. Don't make them into investigators. Don't go out and get it. But when you receive evidence of the crime, keep it and tell us about it and turn it over to us. When we're investigating the suspect, we want to look into his background. Who else has he dated? Who else? I guarantee you that this isn't the first person he's behaved that way toward. There's going to be a history. Prior threats to this victim, other victims, other acts of vandalism, trespass, protective order violations. Those are really, really scary things. When somebody is ordered by a court not to do something and they do it anyway, and it happens all the time, I know, but in these cases, it can be very serious. The history of mental illness, too. Possession of weapons. Great indicators of dangerousness, and so we need to be on top of that stuff. When we're talking, we definitely want to interview the stalker, and typically they'll hopefully talk to you or talk to law enforcement. And what do they think about the victim? Do they treat the victim like that their property, that they belong to them, that they don't have the right to refuse contact with them, that they have this relationship and therefore she has to talk to me? Things like that. Just a simple interview can reveal a lot. This is actually somebody I represented for stalking, but in his interview, when asked when he showed up at some clothing store where the victim happened to be, and he was ordered not to have contact with her, asked, well, was it just a coincidence? And he goes, no, I think it was fate. And so they kind of knew this guy was a little bit off, and they needed to pay closer attention to him and make it clear he was not to do that anymore. And I don't believe he continued. He wasn't found guilty, but I don't believe he continued to stalk the victim either. The contact by police can increase that interest, but it can also be effective, and sometimes we just have to go with what we think is going to be most effective. You can't cover every base. Follow-up investigation, are there witnesses? Is there forensic evidence, independent evidence, circumstantial evidence of the stalking? Is there evidence of surveillance? Will a search warrant reveal information if we can obtain a search warrant for a phone, for a computer, for a home, for an office, for a vehicle, prior criminal record? All of those things are necessary in these cases, and we really want to look at those things. If you do get to search residence or vehicle or office or wherever it might be, are there photos of the victims, drawing or sketches of where they hang out, live, work, go to school? Are there blogs, diaries, anything on fantasies? What websites does the defendant or offender visit? Is there anything disturbing about that? The bookmarks from the history, any devices or objects that could be used to stalk, anything that belongs or relates to the victim can be extremely powerful evidence. All of those things can be important, and we want to look at all of that. If there are subsequent calls for services, is there escalation? Is he doing more dangerous, more risky, more daring behavior? That's a big indicator that this could be going in a bad way. We want to connect the dots, figure out what's changed, address the safety plan so that we can meet that threat, improve the. Check in with other team members. Collaboration is really key, and we want to work closely with our other team members so that advocates know this victim needs support right now and maybe can get in touch with a victim and help that victim out when they need it most. Advocates may know some information, may be able to get the victim to give us that information. Police may need to be involved. We've talked about these systemic challenges, the jurisdictional, our incident response, compartmentalized responsibilities, just that we're only focused on one thing at one time. It may be only this assault and we're not looking at other things. Our lack of knowledge on these things. And we can improve these by improving our strategies. We have resources to combat it. Education and training and resources for our allied professionals and those in the criminal justice system can be very helpful. The coordinated response is going to be the most effective, so work closely with these folks. If you already work closely in a sexual assault response team or a domestic violence response team or domestic assault response team, add stalking to that list of crimes that you talk about, investigate, inquire about with the same victims, because it's probably, or in some of those cases, it's definitely going on. We want to educate and improve awareness of stalking behaviors and risks, identify the context, the pattern, and the mode of stalking, communicate better with one another and share information so that we know everything that's going on, and we'll improve our response and hold more stalkers accountable. Another resource at the Stalking Resource Center is it says PPD Stalking Protocol. It's the Philadelphia Police Department stalking protocol that they developed with the Stalking Resource Center. It's not super lengthy, but it's a fairly detailed document that went into all sorts of things. The first thing is that it's part of their policy that they treat these cases seriously and that they're going to arrest people where they have probable cause that stalking has occurred. It's not going to be ignored, and that was an important part of the protocol. And anytime they have any kind of report or complaint about harassing behavior, the officer should be thinking about stalking and should ask additional questions to figure out if this is an isolated incident or if stalking is going on. They also make the connection between stalking and domestic violence, and they track those cases. They also talk about the timeline. and they want to record as much of the information as possible. As you go through it, I only put a couple of indicators of the protocol on there, but there's a whole bunch more. They hook victims up with domestic violence resources as part of their protocol. They look into possession of a firearm by a stalker, and is there a licensing requirement? Is this behavior something that can cause us to revoke a license or a concealed carry permit, whatever it might be? That's that slide was the where you can find that on the Stalking Resource Center at the National Center for Victims of Crime. You can get it anytime you want. How can we use some of this information, or how do we go after stalkers? We want to have motions and hearings on protection orders. All prosecutors may not be involved in that, but we can certainly make sure that victims get the civil resources they need to seek out those orders to protect themselves. Get bail modifications, ask for no contact, prepare for the coincidence and the love defense, that basically I wasn't doing this to scare her, I just love her. Or I wasn't doing this intentionally, it's a mere coincidence that we showed up at the same 5 places in a week at the same time. Prior bad acts motions or other acts motions, think about those. In stalking, typically all the behavior because of the charge is going to be included, so you may not have to include that. But if there were prior incidents of stalking involving a different victim, then look into that, investigate that, and be prepared to argue a 403B motion or a prior bad acts motion, and look for predicate offenses that can escalate the charge. Most states have a misdemeanor stalking offense. Many have felony-level stalking offense because multiple incidents of stalking, or because certain behavior is combined with stalking, such as use of a weapon or violation of a protective order that suddenly elevates a stalking incident to a felony. So look for those things too. We have to prove the course of conduct, which has to be just more than one incident, 2 or more incidents. Intent can be a tricky one. Most or many of the statutes require that the defendant intended to cause fear. Some say caused fear or should have known that it would cause fear in a reasonable person. Some statutes require that you demonstrate actual fear. Some require that it be fear or that a reasonable person would be afraid, but also of a specific thing instead of just in general fear of an individual, in fear of death, serious bodily injury, or physical assault. Some allow for the emotional distress. Some require that there be some communication between the two, and so certain behaviors that just involve following a person may not qualify. Make sure you have jurisdiction, that at least one of the incidents happened in your jurisdiction. Not all of them have to have happened there, just one. Stalking versus cyber stalking. Some states have 2 statutes to cover the same behavior, but there's a separate cyber stalking statute. Make sure that you've charged under the correct statute, or that you've charged multiple statutes that are supported by the evidence. Some statutes require that there be a certain proximity, or that the individual, if they're under surveillance, be so close to an individual. Those can be tough, so just be aware of what your statute calls for. Some statutes are broad, but most have survived constitutional challenge on the grounds that it was overly broad or void for vagueness, that the behavior was so, that the statute described was so vague that it's void. No one could know or be advised about the fact that they were committing a crime because the statute was so vague. Think about other charges if you don't think you have enough for stalking. Is there harassment, invasion of privacy, threats, trespass, whatever it might be? Think about those things and charge them. Intimidation crimes, think about that. A lot of this is about intimidation. And can you charge those things? If stalking has been charged, don't think that the crime's over because we've arrested. The intimidation sometimes gets really geared up after we charge. And so there could be additional measures we need to take, additional charges we need to file, and additional evidence to be collected. There is a strategic advantage in charging stalking, particularly in the domestic violence relationship, because if there's also stalking going on, if it's a former domestic violence relationship, but now the offender is stalking, if you can get all that stalking behavior in. You start at a certain point and end at a certain point, and all the behavior that happened in between comes in automatically. You don't have to file the 404B prior bad acts motion, because stalking includes all of the behavior. It's all geared toward intimidation, toward threats, toward invoking fear or terror in the victim. So you may have a domestic assault that you're not sure you can get certain other information in, but the facts of the case support probable cause to believe that stalking was also going on, and that may be the way that you get in these prior bad acts without having to go through a 404B, which at least our judges were often reluctant to grant because it's tough for them to say this prior behavior should come in, not just what happened this time. There's a natural inclination not to include that by judges. Stalking also violates federal law. There's interstate stalking. If you have a relationship with your U.S. Attorney's Office and it's a particularly dangerous individual, that may be something you want to look into. The stalking, it has to cross state lines, and the person had to cross state lines with the intent to place in the victim a reasonable fear of death, serious bodily injury, or substantial emotional distress. Just a quick note on Crawford v. Washington in these cases. I just want to talk about a couple things. Crawford v. Washington is the case that requires that the defendant be able to confront and cross-examine the witnesses against him. We can't use some of the old hearsay exceptions that we used to use. They divided all hearsay, out-of-court statements into two categories: testimonial, those that basically are statements that an individual would realize that was going to be used in a trial against them. So your typical officer goes and investigates a car theft. The victim tells them everything about what happened in the car theft. And, of course, the person knows that those statements are later going to be used against the person to charge and prosecute them. Non-testimonial are less formal statements, typically not to law enforcement, that might be to a family or a friend, a family member or friend, that are casual remarks, or you tell a person about what happened to you. Those statements don't require confrontation. And so the idea of thinking about Crawford in these cases is, if you don't have your victim, are there still ways to get the evidence of what happened to the victim in, because the victim happened to tell a family member or friend about what happened while they were upset? So if they did, I'm going through this very quickly, but if you can ask victims, did you talk to anybody immediately before or after the police were called or arrived? They may identify an individual that they gave non-testimonial evidence to about the incident that could come into trial if there is an acceptable hearsay exception for that to come in. And the typical one in domestic violence or stalking would be an excited utterance. People often call a family member or friend before they call the police, tell them all about it. Probably can't necessarily get it in through a police officer, although you can if there are statements that are made to meet an ongoing emergency. Then you can get that in, even if it's to a police officer, if the primary purpose is to aid the officer in meeting an ongoing emergency, and that's why you're telling the officer these things. Then that can also come in. But there still has to be a separate hearsay exception. Excited utterance is one. Present sense impression, then existing emotional or mental state are the big three that we think of in these cases. Think about that. Ask victims about other people they've talked to about the case in case we've lost our victim. Forfeiture by wrongdoing is another, it's an exception to the confrontation clause. An individual forfeits his right to confront and cross-examine a witness because he's engaged in behavior to prevent that witness from testifying. And that's the federal rule. Many states have a codified hearsay exception of forfeiture by wrongdoing. It's a great tool that if you're doing domestic violence cases or stalking cases, that can be very helpful because particularly in domestic violence cases, we lose our victims quite a bit before we get to trial. And this is a way to get their statements into evidence if we can prove that the defendant intimidated or did something with the intent of keeping that victim from testifying, from presenting evidence at court. It applies to potential witnesses, any witness that is unavailable. It doesn't matter if it's testimonial or non-testimonial. You have to put on a hearing. We have resources on this, so I'm not going to go into it too much further, but if you want more information about it, you can contact us or go on our website, and we have two resources, one on Crawford v. Washington and another on forfeiture by wrongdoing, that will lay out exactly what you need to do. It's a great tool. You have to put on a hearing. Typically, the burden of proof, or the standard of proof, rather, is preponderance. There's a few states where it's clear and convincing evidence. But if you can demonstrate that, you may be able to get statements or evidence in absent the victim being present, which can be helpful. We've talked about you definitely want to train and educate all your criminal justice and allied professionals, including the victim, on the risks and methods of stalking, particularly the technology that could be used, and that will improve our ability to identify stalking and increase reporting on the part of victims. We definitely want to have some strategies for early intervention. Could be the law enforcement talking to somebody that may do it. Could be a no-contact letter that the victim has written, but you have law enforcement serve and never have the victim get in touch with their stalker. That is not something that's smart, not something we want to do. But that kind of early intervention may stop it. It may not, but it's a good thing to think about. The mental health system can also be, depending on who this individual is and what he's got going on. Can we refer them to counseling? Is a civil commitment based on the behavior an option? Even if the criminal charge went forward and you got a conviction and maybe it's only a misdemeanor. So you got whatever your maximum misdemeanor carries. Can you also look into a civil commitment and document the stalking behavior for future references or for the civil side of the system cases? Louisiana has a prong in their statute, and I think they just updated, where anybody convicted of stalking is referred for a mental health evaluation. Unfortunately, it does not require that the evaluation be shared with anybody. And I know there's HIPAA concerns sometimes, but there's no system to make sure that the person follows up with mental health resources just if they go and get the evaluation. And there's no real system to ensure that even that happens, particularly if the report's not shared. So you might want to think about having that ordered in certain cases, but have some sort of follow-up. Make sure that they not only got it, but they're following up with recommendations from the mental health evaluation. That could be very helpful. For cyber investigation resources, remember that you have a lot of tech experts at your disposal. State police often will have an independent bureau that deals particularly with technology-related crimes or technology-facilitated crime. The FBI has great resources, and I know we don't deal with the FBI every day, but believe me, I've done it. You can call the FBI. They are available to help you. They will provide services to help you on these things. They're eager to do it. They look into these things all the time, so don't be afraid to reach out to them. You might feel silly calling, I'm going to call the FBI now, but it's a good thing to do. And some local police departments and prosecutors' offices are excellent at that. We're also a resource. The Stalking Resource Center is also a great resource. Just please reach out when you have difficult cases because that's what we're there for, and we're there to help. If you need assistance with warrants or subpoenas, every U.S. Attorney's Office has technology. Their computer hacking intellectual property attorney that is expert at this. If you don't have a relationship with them, it doesn't matter. Just call them. I can't guarantee you every U.S. attorney is going to get back to you or assistant U.S. attorney who's in charge of that, but it's worth a shot when you're concerned about a case and you're not sure of what direction to go in or what to do or what resources or technology-related search warrants or information is available. Department of Justice has a computer crime and an intellectual property section also, and there are the phone numbers that you can call and you can get emergency assistance with cases on these things as well. So reach out to that. Search.org has a lot of online tutorials and information about criminal investigations into this technology-related crimes, so you can reach out to them. A lot of their stuff is free. They also provide technical assistance, so you can call them and get help with some of these cyber-related crimes as well. There's a great document that DOJ, Searching and Seizing Computers and Obtaining Electronic Evidence in Criminal Investigations. It's just a great primer to educate you on what you need to do and how you get at some of this information. If you have to send a preservation letter to a phone company or to internet service provider, that they have samples for you, it's easy to copy, to send. That's a simple thing so that the provider knows to preserve this evidence, even if you haven't already gotten permission from a court to obtain the evidence. And perhaps the court won't grant a search warrant, but we certainly want to make sure that that evidence is preserved in case we need to get it. And then also that NIJ has their investigations involving the Internet and computer networks, which can be helpful as well. Again, we're a resource. We're here. We can do research for you pretty quickly and turn it around very quickly. If you have a new issue or an issue you're not familiar with, we have a lot of case law compendiums already prepared that we can share with individuals. But if we don't, we have a bunch of former prosecutors here, some law associates, and some interns that are ready and very capable at doing research on your behalf in a very short order. So please reach out to us. And again, the Stalking Resource Center at the National Center for Victims of Crime is also a great resource for anything stalking related. So don't hesitate to reach out to them. They have a lot of great statistical information. They have a lot of great statutory information, statutory analysis. They can also hook individuals who need support services up with those services. I refer people to them all the time. I don't prosecute anymore, but we still get victims of stalking calling us and walking into our office, in fact, and we send them right over there, and they hook them up with the services that they need. So don't hesitate to reach out to these resources and these individuals for that information. I really ran through the Crawford and the forfeiture by wrongdoing. A lot of people are not aware of forfeiture by wrongdoing. It is a great tool. I really encourage you to look at that online resource. It is domestic violence cases are the cases that we typically think about using it in, but you can use them in any cases where there's some sort of intimidation or some effort to prevent a witness from testifying, whether it's a gang case, organized crime, domestic violence, stalking, whatever it might be. Just be aware of it. You're going to have a case where forfeiture by wrongdoing, it is a legitimate legal theory in all 50 states, but different states have different requirements. So we'd be happy to help you anytime with either a sample motion or a quick rundown on what you need to do, how you engage or arrange a hearing to have file a motion and do a hearing on forfeiture by wrongdoing so that you can get these statements that a victim has made into evidence. So that's a great resource that everyone should be aware of, and it's not going to fit every case, but you'll have a case that will fit, so you should take advantage of it. That's all I have on stalking. We went over a lot of stuff pretty quickly. That's my contact information. If anybody has any questions, any last-minute questions that they want to ask, please ask away. If you want to email us or call us in the future, please do so. We're here to provide support primarily to prosecutors, but we do it for everybody who calls asking about anything related to violence against women, whether it's sexual violence, domestic violence, stalking violence, dating violence, or human trafficking, which is another area that should be blowing up in everybody's jurisdiction, even if you're not aware of it. So if there are any questions, let Charlie know. Otherwise.
Well, I'd like to go ahead and, first of all, thank you, John, so much for your presentation, and thank you, everyone, for your attendance and your participation and dedication to increasing victim safety and offender accountability in your communities and across the country. If you have any questions, last-minute questions, you can send those on to me, and I'll forward them to John, and we can go over them now, or you can email them, like he said, or call us anytime. I'll just go over a few logistic points right now. When you do exit ILINC, you'll be sent to our website, equitasresource.org, where you can register for future webinars and training events and review any additional information about Equitas, including some of those resources John was mentioning. You're also going to receive a link to SurveyMonkey evaluation for this webinar, along with a copy of the PowerPoint presentation and John's biography following the webinar. Today's webinar was also recorded, and you should receive an email with a link to access that recording shortly after the webinar, so you can go back and listen to anything you might have missed. And also, as John mentioned, please do remember that EQUITAS is a 24/7 technical assistance provider, and we're available to respond to questions, concerns, training needs. So on behalf of EQUITAS, thank you so much for participating in today's webinar, and if there's no other questions, everyone have a great evening. And John and I will stay on the line for just a few more minutes while people wrap up, and if you do have any questions, let us know.
Thanks, everybody.